All righty, good morning. Welcome to Foreclosure Client Counseling. My name is Sam Saad. I'm an attorney here in Southwest Florida, and I'm very excited. Today I'm joined by fellow attorney Gary Green. Gary Green in my office handles foreclosures and foreclosure defense. So he knows what's going on, so to speak, in terms of foreclosures. Very excited to talk about this topic. Interestingly, I should say I'm not excited to talk about this topic because I went through the foreclosure crisis in 2008, 9, 10, 11 there, and that was not a lot of fun, but foreclosures are rising, and we're talking about that today. Of course, Gary and I are attorneys, so we're going to start off with a disclaimer. We're providing advice today and information, but it's not legal advice. We're not creating an attorney-client relationship. If you have foreclosure issues, you can reach out to Gary or myself, and we will get you taken care of or your customer taken care of. A little bit about the firm and who's speaking to you today. Law Office of Sam Saad is a full-service law firm here in Southwest Florida with estate planning, association law, and litigation. And that's where Gary comes in. He'll be talking about the foreclosures later. I, of course, serve on the Legal Resources Committee and the Florida Realtor Florida Bar Joint Drafting Committee. So the contracts that you use, we know those very well. For those of you that tune in to my other presentations, you've seen those. Also, of course, brief commercial for my title company, Paradise Coast Title and Escrow. We do closings throughout Florida and hablamos español for your clients that are Spanish speaking. Let's dive right into foreclosures today. Foreclosures by the numbers. Unfortunately, foreclosures are up nationally, they're up in Florida, and they're up in Southwest Florida particularly. Um, Florida, as of 2026, is in the top three states for foreclosure activity. We are third behind South Carolina and Indiana, with one in every 750 houses in Florida, housing units, I should say, because it includes condominium, in foreclosure. Um, as you can see, Florida saw 10,000 new foreclosure starts in the first quarter of this year, which puts us right behind Texas in terms of volume. And we have quite a few coming in every month. So there's a lot of things causing foreclosures in Florida. We've talked about this in some other webinars, but the rising costs of ownership, condo fees, the problems we're having with tourism, international politics, and then it's just causing some negative equity with the slide in prices, and people who bought in 2021, 2022, really 2023 is the worst, where they are at the peak of the market and now it's coming down some. And if they had a mortgage, they're behind. So looking at Lee County, there's a particular increase in Cape Coral and Lehigh. This smells of 2010, which is unfortunate, but in 2025, October, there were 226 raw list pendants. That's all list pendants. Those are liens on the property filed in the court, and 143 of them were mortgage related. So you can see that about 8% of Lee County homes are underwater, and Cape Coral is fourth nationally in 2025, with one in every 189 homes being in foreclosure. That's a lot. Collier County is a little better, more cash in Collier County. So it's a little bit less intense in terms of foreclosures, but they are rising to one in every 1,045 housing units. Um, you have in quarter one of 26, you have some uh, numbers, 12% year over year increase in filing, but it's not as bad as, like I said, Lee County or the rest of the country, but it's still rising in Collier County as well. So really, what is a foreclosure? What happens in foreclosure? And this is where I'm going to turn it over to Gary. Gary, you're on mute. But let's let Gary take over and talk about foreclosure and the court process.
Hi and good morning. I don't represent banks, but I do represent individuals from time to time that need to foreclose on a mortgage that they hold on behalf of a individual homeowner. So some of these initial comments about the bones of the foreclosure suit process are probably more tailored towards that avenue rather than one that would be defending a foreclosure. But for the individual lender that is in a position where they need to foreclose, there are several things you look at before you file that foreclosure suit. And there are often acceleration clauses in the mortgage and note that state that if the borrower gets behind or fails to make a payment, that the payments are accelerated and the entire balance of the mortgage becomes due. Um, Typically, mortgages require a notice be sent to the borrower that they are in fact in default and that the acceleration process has occurred and demands payment of the full accelerated amount of the balance of the mortgage. Um, Assuming you don't resolve it at that stage with the notice, then prior to filing suit, it's important to obtain a title commitment report. Um, that title commitment report is going to allow you to identify any other lien holders and even second, third, or other mortgage holders that have a lien and a lis pendens, as Sam discussed, on the subject property. And that's important from the lender's perspective prior to filing suit because it's important that the foreclosure complaint include any and all lien holders. I had one I filed last week that there were some code enforcement liens on a property and from the county. And although they were small in amount, there are still liens against the property. And so I had to name the county as a party to the foreclosure suit. And likewise, if there's any other lien holders or mortgage holders, you would need to name them as additional parties to the suit as well as the lender that I'm representing in that case. Um, Now, you know, before I talk about litigation of the foreclosure suit, which is the next slide, there's a variety of options to resolve a foreclosure case, either short of litigation or during litigation. And a settlement of a foreclosure can be negotiated at any stage of the process. There's a variety of options. You can modify the loan. You can discuss a payoff plan that changes the terms and allows the parties to continue moving forward. Sometimes a lender could grant forbearance for a certain amount of time, depending on the circumstances and their position with regard to the foreclosure. There are short sales where sometimes a lender will allow you to sell the property at an amount. If you're underwater, you can sell it at an amount that's less than the balance owed. And sometimes by agreement, the lender will waive or write off the balance of what is owed. Deed in lieu of foreclosure. Sometimes a party can just simply deed the property to the lender or the bank. And if the bank accepts that, then the foreclosure suit doesn't happen. You don't incur attorney's fees and you don't have to go through the litigation process. But if you do litigate a foreclosure, once the lawsuit is filed, there can be, if the borrower does not respond, um, does not file a responsive pleading with the court to the complaint, then the court will issue a default. And that default is followed by a default judgment of foreclosure, and the case ends rather speedily. I talked about negotiated settlements and how that could happen prior to the suit. Again, that can happen at any time during the suit as well. And the deed in lieu is one of those options. Um, Assuming the other party responds, most foreclosures are determined at what's called summary judgment. And that's a hearing that is held at the judge or with the judge prior to trial because there's no issue of fact. Typically, in a foreclosure case, there's an amount owed and it's owed, and there's really no argument about it. And so, if it can't be negotiated, they are usually decided on summary judgment. There are some defenses, such as the lender doesn't have the original note, or other defenses that are again rare, but assuming that you get by summary judgment as a borrower, you take the case to trial where it's determined by the court um, with a full production of evidence at trial rather than at a hearing on summary judgment. The last thing there is attorney's fees. Most mortgage and notes include provisions that provide that whoever wins the litigation is responsible to pay whoever loses the litigation is responsible to pay the winner's fees. So if you're a borrower and you have a foreclosure case filed in court and it ends in either default, summary judgment, or trial, then the lender, the bank, or an individual lender is entitled to recover their attorney's fees, which, if it goes to trial, can be quite expensive. Even at the summary judgment stage, it can become expensive. So now we know how the case ends, either by default, settlement, summary judgment, or trial. And then the next slide covers what happens to the proceeds. If the judgment is entered at either summary judgment, default, or trial, then a judicial sale happens. The court will set a date at the time that it enters the foreclosure judgment. On that date, it will be sold at a judicial auction sale. We have two ways that can go. Sam talked about properties that are underwater. And if the judicial sale results in a amount of proceeds that is less than the mortgage balance, then the lender potentially has the ability to obtain what's called a deficiency judgment. So not only would the lender get the foreclosure of the property and have ownership of the property, but they can get a judgment for money against the borrower for whatever amount was not covered by the judicial sale. If there's any excess, which I had one recently where my client was the second mortgage holder, and the first mortgage holder, which was a bank, sued to foreclose the mortgage. My client was named, as we discussed earlier, because he was also a mortgage holder, and all lien holders have to be included. And in that case, there was an excess of sales proceeds when compared to the amount that was owed under the mortgage. So my client, as second mortgage holder, was able to benefit from that excess, and he will obtain a judgment for what was left in excess of the amount that was owed after the sale. The priority of mortgage and lien holders is is by date. So the first lien against the property is priority number one, and the inferior liens, if you will, would go by date after that first one. So that's foreclosure in a nutshell. You might ask, how much time does it take to get through the process? And that is entirely dependent on which of those stages the case is resolved. Obviously, if a case goes to trial, which is the longest amount of time that it could take, then you could be dealing with a mortgage foreclosure for a year or more. A default is a pretty quick thing. A settlement negotiation happens when it does. summary judgment may be somewhere in the middle. So it's often difficult to know how long a case is going to take unless you are able to, until you're able to know the positions of the parties after litigation is filed. Um, so again, that covers the legal end of the nuts and bolts of a foreclosure lawsuit. And I think Sam has some additional comments, and if there are any
Yep.
questions at the end, I'm glad to
Yeah,
answer.
we'll run through these next few slides, then we'll take some questions. So let's talk about how you can help foreclosure customers. And to be honest, step one is call a lawyer because they are in a legal process at this point. Either they've received a default letter or they've received a summons and they're going, they're in a legal process. So step one is definitely they need to get foreclosure counsel. What can you do and how can you help the foreclosure attorney and your customer and maybe get this to a sale? First of all, you're going to have to do some legwork in the public records. This means that you'll be working with title from the start. It means that you'll be needing draft closing statements, and you'll be looking at the mortgage on the clerk's website. What you're trying to do, first off, you want to confirm address and ownership. Make sure you looked at the right property. Make sure you know who the owners are. Um, Look at the foreclosure stage, as Gary alluded to. There's a lot of process that goes through the foreclosure. Are they past summary judgment? Are we awaiting sale? Did they just get their default notice? Has a case been filed? If a case has been filed, you can go to the clerk of court's website, find a copy of the complaint, and that complaint will contain a lot of information, particularly the amount that is owed at that time, what's being sued for, so we have an idea how far underwater we're really going to be. You'll want to identify the loan type. That'll be stated on the recorded mortgage. Where does the recorded mortgage come from? Also, the clerk of court's website.
It would be attached to the complaint as well.
It would be attached to the complaint as well. That's right. Yes, that's another good place to find it. But what I want to say about the loan type is if there are, for example, FHA loans, there may be things like cash for keys if you get into a short sale and you get a negotiated settlement. If it's a VA loan, there are other options. If it's a conventional Fannie Mae, Freddie Mac loan, there are other options. What Gary was talking about, what we handle a lot is private mortgages that need to be foreclosed on. And those typically less documentation, but more flexibility for negotiating with the lender because you can actually reach a human being. And the other thing you got to look for, as Gary mentioned, is you've got to check for additional liens. So you're going to go to the clerk of court's website. You're going to look up the official records. That's the official records. Search for the name of your borrower and see what else is out there. Now, if the name is John Smith, this is going to be tough. But if it's Sam Saad, you might find a few things that you can help your customer understand their position vis-a-vis getting this property sold. Now, to be honest, it's so important that we have an attorney involved. I have a whole slide on it. And you, as I've said in other presentations, if you've heard me talk before, you want to be the source of the source. That's a very common refrain that realtors will say when they're presenting to other realtors. Be the source of the source. You need to get an attorney involved right away because there's a lot of legal pitfalls that they can get into as soon as that default notice is received. And you want to avoid the unlicensed practice of law because that is a felony in Florida. So be very, very careful about what you say to your foreclosure clients. Tell them you're going to help them. Tell them you're going to help them navigate the process. But your help is to provide people who are experts in a particular field. And then, of course, your job is to get the property sold before the court sells it. So to get that done, let's talk about what you have to figure out in terms of pricing, where you're at in the market, where you're at with the mortgage, other loans, and does this customer have equity or are we really in a short sale situation? So I would start off once you've had your meeting, you've talked to the seller about their issues, and you've potentially gotten them an attorney. Get an estimated market value. That's a comparative market analysis, a broker price opinion. Figure out where you are in terms of the market and the value of the home. Get with title to request a mortgage payoff. If you don't know how to do that on your own, you can look at the mortgage statement of your customer's mortgage statement. And there may be a phone number where the customer can call or a website where they can go to and get a payoff. That's a very important number because that's the number you have to get over to get out of a short sale. Um, if you're under that number, or if there are additional liens, then you are in a short sale situation. Identify arrearages. How far behind is this borrower? This is an important fact because many lenders, if they're Fannie Mae, Freddie Mac loans, won't talk to you until you are in a significant arrearage, which means you owe 3 months or 4 months of mortgage payments. Perhaps you haven't paid your tax, you have to pay the taxes. Maybe you're no longer maintaining the insurance. Find out what the arrearage is. And with all of that information, you can determine the equity position. That is how far underwater your borrower is. And then you know what you're up against in terms of short sale or regular sale. And of course, the further down you are relative to the amount of what's owed is really how hard you and I are going to be negotiating with the lender, with the other lien holders to figure out how to get this house back into position or get this borrower back into a position where they are no longer swimming in debt. So you have a lot of options, of course, as Gary mentioned. You can work for a reinstatement of the loan with the lender. You could modify the terms of the loan. That typically means extending the term, maybe from a 30-year to a 40-year, or whatever the term is, extending that out. Maybe if you can negotiate an interest rate, it's pretty tough to get a lower interest rate, particularly in this environment where interest rates are kind of rising. Same thing goes for refinances. If you can refinance into a different loan product with lower costs or a better interest rate, that may be an option. If you're not underwater, you can sell the property as quickly as possible and pay off the debt. If you are underwater, then you're going to be in a short sale. And we have a whole seminar on short sales, what that means and how you deal with that, which you can find on my YouTube channel. Gary mentioned the deed in lieu. This is often the best option, in my opinion. You simply give the property to the bank in exchange for a negotiation where you remove the deficiency judgment. What is the deficiency judgment? Well, Gary mentioned if the property sells for less than what is owed, the judge is going to give a judgment to the lender, and that lender can then collect from the borrower. And the funny thing about this is you say, um, hey, here's the property back. I know I still owe you 100 grand. And then I've had the case where the lender came back years later and said, we want our money now because we see that your credit's improved. So that's always an interesting situation. So negotiating that deficiency judgment up front when you do a deed in lieu or a short sale is very, very important. And of course, the nuclear weapon of foreclosure defense is bankruptcy. And neither Gary or I handle bankruptcies. We would refer you to outside counsel for bankruptcy expertise. But in short, bankruptcy tolls or stops all the foreclosure litigation. It freezes everything for the borrower, and they go through the bankruptcy process. And that there they can either get rid of the house through the bankruptcy court and be relieved of the debt, or they can reaffirm the debt and keep the property, but maybe get rid of all their other debts so they can afford the house. Again, bankruptcy is its own specialty, and you need to be with a bankruptcy attorney that knows exactly what they're doing. In terms of listing the property, you need to confirm the timeline. You know, Gary mentioned you've got a letter saying that you're a notice of default coming out. Then you've got eventually the foreclosure complaint being filed and served. followed by a discovery process and summary judgment or a court trial, and then foreclosure judgment. So where are you in the process? And don't be afraid to price your listing aggressively. The seller already knows in 99% of the cases that they're getting zero, or you tell them they're getting zero from this transaction because they're underwater. So really what you're talking about is negotiating that deficiency judgment. And most lenders, particularly on the Fannie Mae, Freddie Mac products, if it's not unbearably bad, they will relieve you of that deficiency. And then, of course, in the MLS, you have to disclose the foreclosure status. Don't forget that there's a checkbox in MLS for that. You're going to be coordinating with the lender. That means working with title and the foreclosure attorney to coordinate with the lender. If the property is in foreclosure and that the case has been filed, very often you will need defense counsel, that's Gary or I, to go to the lender's counsel and say, hey, we're getting this in a short sale. Can you work with us? Can you slow the process? Are you rushing to judgment? And we coordinate and work with the lender because they don't want to pay the lawyer and they don't want to deal with a property. Their job is to loan money. They're not in the real estate business, they're in the lending business. And then, of course, prepare for the short sale process on an as needed basis, which is most of the time. Deadlines and risks. And Gary, you may want to jump in on this as well, but once that foreclosure case has been filed, a process server, that's a person, will find the borrower wherever they are, work, home, the grocery store, and hand them, literally physically hand them papers. That's service of process. From there, the borrower has 20 days to respond. And so you need to get them an attorney and you need to get the property listed so we can say to the foreclosure counsel, hey, we're trying to get this sold in a short sale. Don't hurry through the process. We think we can get this property sold. You're going to monitor the sale date. If you're coming up on a foreclosure sale, obviously you need to get the property sold and closed and the money to the lender prior to the sale date, because the lenders actually don't have a lot of control over the sale date. Once that foreclosure judgment has been entered by the court and the lender applies for the court ordered sale, it's really in the clerk's hands. And Kim, I'll address IRS liens in a minute, but it's really in the clerk's hands. And then you're talking about deficiency judgments and all types of things that are going to attach. So if there is a significant deficiency, as in the property is significantly underwater, then you're going to need some additional help. Again, that's an attorney negotiating for the with the lender's counsel. And there is always a credit impact in foreclosure. It's funny, when people file bankruptcy, sometimes their credit goes up because they get rid of so much debt. That does not happen in foreclosure. You're very likely going to see your credit score go down, and you're going to see a line on your credit that says that you had a mortgage that was paid otherwise than agreed, or whatever the nomenclature that the credit agency uses. So let's say you're meeting with your customer, they're telling you about their foreclosure problems. What are you going to do to help them besides just go get them a lawyer? You want to be involved, you want to get your property sold, hopefully you get a commission out of it. And what are you going to do to help get this organized? And that is get the documents together. You're going to ask the borrower, this customer, for their mortgage statements. If they've been served, you're going to ask them for a copy of the complaint. They're going to need to produce W-2s if they're going into a short sale and tax returns to the short sale lender. They're going to need a hardship letter that says why they're in having a financial difficulty. Did they lose their job? Did their spouse pass? Did they get divorced? A kid got hurt? You need to put that information into a letter form, and it's going to go to the lender for them to approve the short sale, hopefully. And this is a great place, by the way. Don't be afraid of it. Put your problems into ChatGPT and ask it for a hardship letter. No shame in that. Uh, AI is going to help us through all these processes. And then authorization forms. There may be a third-party authorization form that the lender has so that the lawyer or you can talk to the lender and get the information from the lender. That's the biggest one. There may be other authorization forms that are going to be required by various parties for you to be involved. One thing I would suggest is do not, and I've seen this realtors do this in the past, do not get a power of attorney to negotiate for your customer or to work for your customer. Let the attorney handle it. It's a legal process. Your job is to help facilitate the sale of the real estate. And the other thing that you can do is help communication expectations. Communication is huge in these processes. This customer is going through a very difficult time. Again, a divorce, a death, a problem with a child. These are the big ones. Loss of job. These are things that really affect us all. And you've got to come in, you've got to set timeline expectations for how long you think it's going to take to get this property sold. You're going to explain to them briefly outline the foreclosure process. Remind them that they cannot wait to get things done because the court is not going to wait and the lender's obviously not waiting since we're in foreclosure. And then documenting all communication is essential for you to protect yourself and your brokerage. If you have a call with somebody, send a follow-up email and copy the attorney, copy the borrower's attorney. Let the people know, hey, listen, I spoke to the lender, or I spoke to whoever title, and they are working through this process to get us a CMA. Whatever step you are in the process, document it. And then always avoid guarantees. We don't know all the facts. We never know all the facts. As Gary mentioned, it's kind of a process. Once the process started and you're in foreclosure, you're going through foreclosure and you're trying to get out of it as quickly as possible by settlement, hopefully, sale of the property and release of that deficiency. Of course, if we get to judgment stage, that's a problem, but avoid guaranteeing an outcome. Next thing I'll say is be very careful. You cannot charge upfront fees. That changed back in I believe it was 2010 or 11. The Attorney General of the state of Florida put out a advice. You can get a commission on the sale on the HUD, but you cannot charge an upfront fee. You cannot provide legal or tax advice, and you need to make sure that you ensure proper disclosure. That's in the MLS. And the last thought I've got about how to really serve your customers is check in with your client. Again, it's unfortunate, but when we do these foreclosures, you and I, Gary, we become counselors. We got to listen to the hardship, understand our client's needs, and we've got to track the foreclosure status, adjust the pricing to the market, coordinate with other professionals. These are the things that make you look really good as a realtor and get you more business. And with that, we've got some questions in the chat. So let's go through this. How about when there's an excess of proceeds, does the borrower get it after the foreclosure sale? Abenia, if there's an excess of proceeds, and all the creditors have been paid off, then yes, the borrower can get some money out of the foreclosure sale. Cindy's asking 20 calendar days or business days. Cindy, it's 20 calendar days to respond to the lawsuit. And then Kim, you were asking about IRS liens. IRS liens are their own animal. They are still due after foreclosure, like all other liens. If you try to negotiate with the IRS, you let me know. I've never had success negotiating with the IRS, but we can get IRS payoffs. There's an office in Fort Myers if we're in a hurry. Otherwise, we file a form with the IRS, and it takes a couple of weeks to get the IRS lien payoffs. Benia is asking, is significant increase of property tax a hardship considered by lenders or a judge? No, that's a great question. the fact that you pay property taxes should be known to the borrower from the beginning. And the fact that the property taxes went up significantly after the year after purchase should also be known to the borrower, and that should be planned for. In most mortgages, those amounts are covered in the PITA payment, the principal, interest, taxes, and insurance monthly payment. And if that increases to the point where the borrower can no longer afford it, well, that's a hardship, but it's not one that's going to get you out of foreclosure. Michael's asking the tax. Oh, yes, Michael, that is a great question. Did the tax forgiveness expire for short sales? Yes, it did. If you get a short sale and you get a waiver of the deficiency, either for short sales or mortgages, you will pay taxes on that income. So just because you get a waiver of the amount owed, you're still going to pay taxes on it as income. So that's just how the government gets you coming and going. Do we have other questions? Feel free to unmute yourself or type it in the chat. Anna, yes, that applies to primary residences. If you are in a short sale or a foreclosure of your primary residence, you still would owe, and you get the deficiency judgment waived, you would still owe income taxes on that cancellation of indebtedness income. That's what it's called, cancellation of indebtedness income. Other questions? Gary, we were so good, they don't have any questions.
Oh,
Come on, there must be some. All right, seeing none. Well, thank you all very much for your time today. We are only 7 minutes over today, which is not bad. If you have any questions about foreclosures, please reach out to Gary or myself anytime. Thank you all for your time.